damages. I'm here to discuss the concept of moral damages, elements, proof, and causation. So firstly, we should discuss the concept of moral damages. As defined in Article 2217 of the Civil Code, moral damages include physical suffering, mental anguish, fright, serious anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury. Though incapable of pecuniary computation, moral damages may be recovered if they are the proximate result of the defendant's wrongful act or omission. It is clear then from this article that moral damages can be recovered in every case of wrongful act or omission, since wrongful act or omission is a broad term which may include delict, quasi-delict, or breach of contract. The award of moral damages is designed to compensate the claimants of actual injury and is not meant to enrich the complainant at the expense of the defendant. They are awarded only to enable the injured party to obtain means, diversions, or amusement that will serve to alleviate the moral suffering he has undergone by reason of the defendant's culpable action, as is stated or ruled in Kerhoff versus TA, a 1997 case. Also, a 1997 case, People versus Aringe. Moral damages are not awarded to punish the defendant. It must be understood to be in the concept of grants, not punitive or corrective in nature, calculated to compensate the claimant for the injury suffered. So, what is the effect of death? A claim of moral damages does not survive the death of the plaintiff. The right of moral damages is not transmissible to the injured party's substitute because it is extremely personal to the injured party. So, here, the question as to whether an action survives or not depends on the nature of the action and the damages sued for. So, in the cause of action which survives, the wrong complaint of affects primarily and principally property and property rights, the injuries to the person being incidental. While in the causes of actions which do not survive, the injury complained of is of the person, the property, and the rights of property affected being incidental. As ruled in Bonilla versus Barcena, a 1976 case which is cited in Cruz versus Cruz, which is a 2010 case, and Ruiz versus the Court of Appeals, a 1999 case. The adjudication of moral damages, the sentimental value of property, real or personal, may be considered as is stated in Article 2218 of Civil Code. Willful injury to property may be a legal ground for awarding moral damages if the court should find that under the circumstances such damages are justly due. So, next I will discuss the elements to claim moral damages. First, there must be injury, which is whether physical, mental, or psychological, which is clearly sustained by the claimant. Second, there must be culpable act or omission factually established. Third, the wrongful act or omission of the defendant is the proximate cause of the injury sustained by the claimant. And fourth, the award of damages is predicated on any of the cases stated in Article 2219. Article 2219 pertains to the cases when moral damages may be awarded. So, next topic, proof and causation. So, is there a need of proof and allegation? No proof of pecuniary loss is necessary in order that moral damages be adjudicated. The assessment of such damages is left to the discretion of the court, according to the circumstances of each case. However, there must be proof that the defendant caused physical suffering, mental anguish, fright, anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury to the plaintiff. So, without allegation and proof of such sufferings, then no moral damages can be awarded. Nevertheless, the language of the law need not to be used to warrant the award of moral damages. So, as long as there is satisfactory proof of the psychological and mental trauma actually suffered by a party, the grant to him of moral damages is warranted. Aside from the fact that there is a need for the claimant to satisfactorily prove the existence of the factual basis of the damages, it is also necessary to prove its causal relation to the defendant's act. While moral damages are incapable of pecuniary estimation, they are recoverable if they are the proximate cause of the defendant's wrongful act or omission. Are there instances when no allegation and proof are required? Yes. The exception to the rule is that the factual basis for moral damages must be alleged are in criminal cases. So, moral damages may be awarded to the victim in criminal proceeding in such amount as the court deems just without the need for pleading or proof of the basis thereof. Thus, moral damages are mandatory in cases of murder without need of to allege and prove such damages. Similarly, moral damages are automatically granted to a rape victim without the presentation of further proof other than the commission of the crime. So, noteworthy, the concept which is stated in Article 2217, the concept of moral damages, the four elements, so please remember, and proof and causation. Thank you.
Cases when moral damages may be awarded. Under Article 2219, moral damages may be recovered in the following and analogous cases. First, a criminal offense resulting in physical injuries. Second, quasi-delicts causing physical injuries. In one case, in the case of Javares versus People of the Philippines, the Supreme Court stated that an award of 5,000 pesos moral damages is appropriate for slight physical injuries. Third, seduction, abduction, rape, or other lascivious acts. Fourth, adultery or concubinage. In the case of Ataday versus People of the Philippines, in cases of acts of lasciviousness under Article 336 of the Revised Penal Code in relation to Section 5B of RA 7610, the award of moral damages should now be fixed in the amount of 50,000 pesos, taking into account that the imposable penalties for the said crimes are within the range of reclusion temporal. Fifth, illegal or arbitrary detention or arrest. 6. Illegal search. 7. Libel, slander, or any other form of defamation. 8. Malicious prosecution. 9. Acts mentioned in Article 309. Under Article 309, it states that any person who shows disrespect to the dead or wrongfully interferes with a funeral shall be liable to the family of the deceased for damages, material and moral. Number 10. Acts and actions referred to in Articles 21, 26, 27, 28, 29, 30, 32, 34, and 35 of the Civil Code. The parents of the female seduced, abducted, raped, or abused referred to in number 3 of this article may also recover moral damages. The spouse, descendants, and brothers and sisters may bring the action mentioned in number 9 of this article in the order named. So the enumeration in Article 2219 is not exclusive. The term analogous cases referred to in Article 2219 following the ejusdem generis rule must be held similar to those expressly enumerated by the law. The Commission also felt that the analogous cases for recovery of moral damages should be left to the courts to determine, since the field of moral injury is a vast one in the civil and criminal laws. And in view of the fact that the question of moral damages is a novel one in the Civil Code, the Code Commission considered it advisable for the convenience of the bar and the bench to mention some cases as examples of wrongful acts where moral damages may be recovered. So the enumeration in Article 2219 are only examples provided by the Code Commission for the convenience of the bar and the bench. So another case when moral damages may be awarded is provided in Article 2220 of the Civil Code, where willful injury to property may be a legal ground for awarding moral damages if the court should find that, under the circumstances, such damages are justly due. And the same rule applies to breaches of contract where the defendant acted fraudulently or in bad faith. So if the breach of contract was not done fraudulently or in bad faith, then moral damages may not be awarded. Another case is by special rule in Article 1764 in relation to Article 2206 of the Civil Code. Moral damages may also be awarded in case the death of a passenger results from a breach of carriage. In labor cases, moral damages may be recovered where the dismissal of the employee was attended by bad faith or fraud or constitute an act oppressive to labor or was done in a manner contrary to morals, good customs, or public policy. In the case of Macondray & Co. Incorporated versus Villarosa et al., Justice Capistrano explained that moral damages can be recovered in every case of wrongful act or omission, causing as the proximate result thereof physical suffering, mental anguish, fright, serious anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury. So what are the factors that the court may consider in determining the amount of moral damages? Since there is no hard and fast rule in the determination of what would be a fair amount of moral damages, since each case must be governed by its own peculiar circumstances, and moral damages are not intended to impose a penalty to the wrongdoer, neither to enrich the claimant at the expense of the defendant, but to enable the claimant to find some cure for the moral anguish and distress he has undergone by reason by the wrongful act of the respondent. So the first factor is the extent of humiliation experienced by the claimant. Moral damages was awarded and fixed because of the humiliation caused by the discriminatory acts. Second, pain and suffering. In case of criminal taking of life, the Supreme Court held that it is inherently human to suffer sorrow, torment, pain, and anger when a loved one becomes the victim of a violent or brutal killing. Such violent death or brutal killing not only steals from the family of the deceased his precious life, deprives them forever of his love, affection, and support, but often leaves them with the knowing feeling that an injustice has been done to them. And for this reason, moral damages may be awarded even in the absence of any allegation and proof of the heir's emotional suffering. The third factor is the official, political, social, and financial standing. In the case of Producers Bank of the Philippines versus Court of Appeals, in this case, there was a wrongful dishonor of a check that was issued by the plaintiff, and it affected his credit standing. Since the financial credit of a businessman is a prized and valuable asset, the Supreme Court considered the credit standing of the plaintiff in awarding the moral damages. But we should take note that these are just factors the court may consider in determining the amount of moral damages. As we said a while ago, the court are given discretion to determine the amount of moral damages because each case is governed by its attendant particulars, and moral damages awarded must be commensurate with the loss or injury suffered by the claimant.
Okay, so good afternoon. So we would now go to the topic, who may recover for moral damages. As a general rule, the person who endured physical sufferings, mental anguish, fright, serious anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury is the person who can only recover for moral damages. However, there is this exception to the rule. So what are the exceptions? First is the relative. Sino-sino nga ba yung mga relative na sinasabi according to Article 2219? So first, we have the parents. The parents of a female seduced, abducted, raped, or abused may recover for moral damages. So aside from that are the spouses, descendants, ascendants, and brothers and sisters. So according to that one, if the basis of the claim is physical suffering, the only one who suffered and not his or her spouse may recover. Likewise, a person who sympathizes with an injured relative is not entitled to recover for the physical sufferings of another. However, as stated in the exception to the rule, spouses, descendants, ascendants, and brothers and sisters may demand for moral damages from the anguish by reason of the death of the deceased if any person disrespected the dead or wrongfully interferes with the funeral. And we must take note that it must be proven that they suffered mental anguish, serious anxiety, or moral shock and similar injuries. The relatives of the deceased victim specified in Article 2209, specifically item number 2, in quasi-delict cases are not prescribed from recovering moral damages in some meritorious cases. The brothers and sisters cannot recover for moral damages for the death of their sibling. Okay? But however, a person exercising substitute parental authority is entitled to moral damages. Okay. So we have here a question. In case of successful suit for damages resulting from loss of marital consortium, how should the court determine the amount to be awarded? So paano nga ba? Before that, we must answer what is loss of marital consortium means. Loss of marital consortium is the type of harm that usually falls under the category of general or non-economic damages, meaning that there are losses for which money is the only rough substitute. So typically, these kind of losses are left to the discretion of the court or the jury. However, since the kinds of damages are also difficult to quantify, you may need to retain an expert opinion to provide a more precise monetary value for the loss of consortium. So basically, nakabase yung amount of damages or yung damages awarded to the extent of moral damages that has been inflicted to the victims. So we have here another question. What if a woman becomes seriously injured by a vehicular accident, but because of the injury to her nervous system, she is no longer capable of understanding the pain she is currently in? Can her husband claim moral damages for the pain he feels seeing her in such state? So in the question number 2, nagkaroon ng accident. However, the person cannot identify her state na kasi nagkaroon siya ng nervous system. So ang tanong, can her husband claim for moral damages? According to Article 2219, yes. As an exception to the rule, the spouse is bestowed by the law the right to claim moral damages in respect to his wife.
So now we move on to question number 3. It says that should testimony for moral suffering be required even for murder? What about the requirement in Article 2217? The answer here is no. It was actually held in several cases decided by the Supreme Court that in criminal case proceedings, moral damages may be awarded to the victim in such amount as the court deems just without the need for pleading or proof of the basis thereof. It is therefore mandatory in cases of murder without need to prove or allege such damages, such as in case of People versus Panela. Award for moral damages can be made without need of proof other than the death of the victim. However, there are some cases like in People versus Panado where it was held that it is only in cases of violent or brutal killing of victim which invariably and necessarily brings out the emotional pain and anguish on the part of the victim's family. Therefore, there is no more need for allegation or proof of the mental suffering required under the required for moral damages to be awarded. So we move on now to question number 4, where it states that if A willfully destroyed the old car of B, can B be awarded moral damages if B did not really care about the car? So the answer here is actually no. Based on the no, B may not be awarded moral damages. So we have already discussed under the concepts part of our discussion under moral damages that for moral damages to be awarded, of course, there must be proof that the defendant caused some or any of this enumeration. Number 1, of course, physical suffering. Number 2, mental anguish. Number 3, fright. Number 4, serious anxiety. Number 5, besmirched reputation. Number 6, wanted feelings. Number 7, moral shock. Number 8, social humiliation. And number 9, of course, if there are similar injuries to those that are enumerated. Without, of course, allegation and proof of such sufferings, then no moral damages can be awarded. The claimant must also satisfactorily prove the existence of the factual basis of the damages. It is also necessary to prove its factual or its causal relation to the defendant's act. Moreover, Article 2220 states that willful injury to property may be a legal ground for awarding moral damages if the court could find or should find that under the circumstances such damages are justly due. Therefore, in this problem given, if B's cause of action for recovery of moral damages is not predicated upon any of those that are specifically enumerated or required in order for the proper awarding of moral damages, therefore, moral damages may not be awarded in B's favor. So we move on to question number 5, where it says that should moral damages be awarded for an unfounded civil suit? Why? The answer here is, of course, no. It was held in several cases that the law could not have meant to impose a penalty on the right to litigate. The anguish suffered by a person for having been made a defendant in a civil suit would be no different from the usual worry and anxiety that is suffered by anyone who is hailed to court. A situation that cannot by itself be a cogent reason for the award of moral damages. If the rule were otherwise, then moral damages must every time be awarded in favor of the prevailing defendant against an unsuccessful plaintiff. Moral damages cannot be assessed against the plaintiff by the mere fact that he or she filed a case against the defendant so long as the same was done in good faith. The rule applies even if the plaintiff's case is declared to be unfounded. No damages can be charged on those who may exercise the right to litigate in good faith even if done erroneously. If, however, there is clear abuse of court processes, this may justly or justify the award of course for moral damages.
Question number 6. Should juridical persons be awarded moral damages? The answer is no. Citing the case of ABS-CBN versus Court of Appeals, the Supreme Court held that artificial beings are not entitled to recover. Primarily, moral damages are awarded to compensate mental distress or other intangible injury. Since a corporation has no feelings, no emotions, and no senses, it cannot experience mental anguish. Hence, it cannot recover moral damages. In the case of NPC versus Philip Brothers, the court held that while it is true that besmirched reputation is included in moral damages, a juridical person still cannot recover. To reiterate, an artificial person only exists in legal contemplation. It has no feelings, no emotions, and no senses. The exception is provided in Article 2219, Item Number 7. This provision expressly authorizes the recovery of moral damages in cases of libel, slander, or any other form of defamation, since the provision does not qualify whether the plaintiff is a natural or juridical person. In this case, moral damages may be recovered by a juridical being. Question number 7. Should the amount awarded for moral damages depend on the amount of suffering for the cost of alleviating the suffering? The answer is yes. This is manifested through various cases decided by the Supreme Court, one of which is the case of Ramos versus Court of Appeals. The victim in this case is a comatose patient for over 14 years. The Supreme Court justified the 2 million moral damages where it said that the burden of care has been heroically shouldered by her husband and children, who, in the intervening years, have been deprived of the love of a wife and a mother.